Everybody ready? Good evening and welcome to the Kent County Board of Adjustment meeting for February 20th, 2020. Gonna call the public hearing to order. When you have a moment, will you call the roll, please?
Yes, absolutely. Mr. Cusick?
Here.
Mr. Saunders?
Here.
Mr. Crossan?
Here.
Ms. Hudson?
Here.
Mr. Carter?
Here.
Mrs. Denny?
Here.
Roll call shows 6 present, so we do have a quorum.
Thank you. And then would you introduce the staff?
Absolutely. Hi, my name is Jason Berry. I'm a planning supervisor here at Kent County Department of Planning, and to our left are 2 of our planners in our office, Jamie Fensky and Scott Blair. And to my right is the legal counsel, Fred Townsend.
Thank you. At this time, I'm going to ask everyone to rise and pledge allegiance to our flag. Okay, any additions or alterations to the agenda?
No changes to tonight's agenda.
Great, okay, so will you introduce the public hearing?
Thank you. Good evening, everyone. This hearing is being conducted for the purpose of providing the citizens of the county an opportunity to present testimony on these applications before the Kent County Board of Adjustment. Everyone will have the opportunity to speak. This will provide those who wish an opportunity to give testimony. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they speak clearly. Furthermore, there shall be no cross-examination of witnesses permitted during the public hearing, but the board can ask the applicant questions after any opposition if necessary. As a courtesy to the other participants in this hearing, a maximum of 5 minutes will be allotted to any person who wishes to provide testimony for any application. The chairperson of the Board of Adjustment has the discretion to allow additional time if deemed to be necessary. Statements presented at the meeting are to be made from either of the podiums at the front of the room, and for the record, please give your name, address, and allow our attorney to swear you in prior to providing testimony regarding your application. Copies of any written statements or exhibits used during the hearing should be presented for identification so that they may be included in the permanent record. The procedure on each application will be as follows. The legal notice will be read on each case prior to the receipt of testimony. There will be a brief explanation of the application by staff. The board will then receive testimony from all those in favor of the application, followed by testimony of those who may be opposed. Once those persons in favor and those in opposition have had an opportunity to speak, the hearing on the application will be declared closed. Decisions on these applications will be made by the board during the business meeting, which will follow the public hearing this evening. However, you are not required to remain after the public hearing once your application has been heard and closed. During the business meeting, the board will consider all information of record. A common vote of 4 members of the board shall be required to make a decision on each application. If you do not wish to wait for the business meeting later this evening, you may call Kent County Planning Department tomorrow between 8 a.m. and 5 p.m. at 744-2471 or check the Kent County Planning Department website or Twitter page to learn of the board's ruling. All applicants will receive written notification of the board's decision. This notice may not be mailed until after the next scheduled meeting, but if approved, you are welcome to apply for any necessary permits prior to receiving this by mail. Please keep this decision in your records for both you and future property owners. The public notice of this evening's hearing was published on February 3rd in the Delaware State News. In addition, all of the subject properties were posted with a sign prior to the hearing to further notify the public of the nature of the application. Thank you.
Thank you. This time we're going to have a statement by our counsel. the purpose of which is to help those who want to give testimony this evening an opportunity to understand what is and is not acceptable as testimony before this particular body. Mr. Townsend.
Thank you, Ms. Denny. The standards for the granting of variances are set forth by the Delaware Supreme Court in the case known as Board of Adjustment versus Quick Check Realty, Inc. And as it was in that case, the typical variance application is for relief from area restrictions. The standard applied to area variances considers whether a literal interpretation of zoning regulations result in exceptional practical difficulties of ownership. In order to determine whether the exceptional practical difficulty test is met, the board must weigh the following 4 factors. First, the nature of the zone where the property lies. Second, the character and uses of the immediate vicinity. Third, whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And fourth, whether failure to remove the restriction would create unnecessary hardship or exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This factor is satisfied only when the difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. Note that the inability to improve one's business or to remain competitive due to area limitations may qualify as a legitimate exceptional practical difficulty. And it is with respect to this factor that the board considers whether the applicant is seeking more relief than is necessary to relieve the asserted difficulty. In general, the board is not permitted to consider factors other than the 4 I have listed, so those speaking in support of and in opposition to applications are urged to present only information bearing directly on the 4 factors, which I'll restate briefly. Again, they are the zoning district, the character of the immediate vicinity, the effect on neighboring properties, and whether the applicant faces exceptional practical difficulties of ownership. In particular, presenters are instructed to exclude from their presentations any discussion of personal disputes or acrimony between the applicant and neighboring property owners, as the board is unable and unauthorized to resolve those disputes. Presenters must limit their remarks to the issues the board can decide. Madam Chairman, that concludes my remarks.
Thank you. Mr. Townsend. Okay, so whenever you're ready, I'm ready. Start with the first case.
Thank you. The first application this evening is for A-20-01, Gill Brothers LLC. They seek a variance from the required 50-foot minimum distance of any building from a residential property line, and this is to enable the use of an existing building for an auto repair business. The property is located on the southeastern intersection of North DuPont Highway, which is US Route 13, and Fast Landing Road, which is Delaware Route 42, east of Cheswold. It's in the 3rd Levy Court District, and the property is Zone BG. So as I mentioned here, this property here is on the corner of Route 13 and 42. You can see it out down there in black in the southeastern corner. The request this evening, as I mentioned, is for the required 50-foot setback from any building being used for an auto repair business. There are 2 existing buildings on site you'll see in your exhibit. One of them has never been approved for auto sales, so that's why we're here today. It's this building here is the subject of this variance. That distance that it's currently located from the property line is just over 20 feet. So we're looking for a variance from the 50-foot required to 20 feet for this existing building. The staff has recommended approval of this request. Now we'll just show you some pictures around the property. I think we can probably clear that off now. There we go. This is just looking at the back side of the building. There is an existing auto repair use in the other building right now. That's looking down that side property. The building in question is this taller building that's in the back there, which you'll get another picture of here in a second. That's a good look down that residential property line. As the board saw in their report, one of the conditions for auto repair or auto sales is a 6-foot buffer along any residential property line. You can see the portion of this property already does have that fence. That's right here to our left. There's a residential property on the other side of that fence. As you'll see, that will need to be extended, if approved today, to cover the rest of that property line where that other building is located. Here's just looking at the other activity that's on the site right now. This is some of the cars they have out there. This is looking down the southern property line. Here's the site itself. Again, that white building, that double-story building there is the subject of this request today. Here's looking at that building again and some of the other cars on site. And here's the other direction down that side property line. You can see on the right-hand side of your screen now, that's the residential property and the residential property line in question. The building looking to be used, that's 20-foot distance, is right there to the left. So basically then from that building to this property line is 20 feet. You can see it again right there. That's that 20-foot distance where that 6-foot fence will need to be extended if approved today. And here's a look at the aerial photo of the property, and then this is just a larger view of the area at that Cheswold intersection. So that's what I have to say. If the person representing the application come forward to either podium, state your name and address, and we'll have our attorney swear you in.
Okay, we do one at a time.
I'm speaking on his behalf. Hello, my name is Anmal Gill. My address is 466 Topaz Circle, Dover, Delaware.
Sir, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please proceed.
First, I want to thank you guys for having us here. So I want to speak on behalf of the fourth thing that Mr. Townsend mentioned, the difficulties that it would cause the business. So we've had the property since my dad signed the lease around 2015, and we've had it since 2015, and my father, he bought it in 2018, and ever since 2018, we've been looking forward to improving the site. As you can see by the photos, it's in a state right now where it's not, how can I say it? It's not very like pretty, to use a rudimentary word, and we've got a lot of even our employees and some of the customers that come by, they say, oh, you know, it's not very like, it's not very attractive looking. And so the thing I want to bring up is that to expand our business and to compete with other businesses, there's currently a couple of tire shops, not even 2-3 minutes.
Us to get the permits as
Neighboring property.